everybody. Good morning. I hear normally the session starts a bit later, so thank you for getting up a bit earlier to attend this webinar. So what we will cover today is like a brief introduction to intellectual property rights. So for me, it's important that you are aware that it's more than just patent rights or inventions. So we have also copyrights, trademarks, design rights, databases, and stuff like that. So I'll explain very briefly to you what they are, how to obtain them, and actually who owns the rights. If you make it as a freelancer, if you make it during an assignment, and whether or not you should enter into agreements and what you should do to help the one who gives you the assignment, or make sure that you still keep certain intellectual property rights. I will not be able to go into too much detail on every single intellectual property right, but I just want to give you this overview. And I hope to finish in about 30 minutes, which leaves us enough room to have like a discussion or have your most important questions answered, or that I can at least give you some kind of practical advice there as well. So I would suggest, without further ado, that we just get started. So that's me. I'm Stan De Vocht. I have a legal background and specialization in intellectual property. I did different jobs before, but now I'm the founder and the CEO of Creative Sheld. And as Elena explained, we help the Belgian freelancers to make the most of their copyrights. And so it's not intellectual property in general. We focus on copyrights. Why? Because there's a very interesting tax incentive here in Belgium with regard to copyrights. So there are different tax benefits in different countries related to intellectual property rights. Here in Belgium, the one with regard to copyrights is very interesting. And so that's what we help our freelancers with, is to obtain and to make sure they use it in a proper and correct and very easy to use way. So if you're located in Belgium and you pay Belgian taxes, have a look at our website and learn more about these tax incentives and how we can help. So what will we cover today? I will talk briefly about patent rights, copyrights, software, trademarks as well, domain names, and last but not least, trade secrets, which is not really an intellectual property right, but can also have like a very big value to your activities or to your assigner activities. So, and then I will end with some tips and tricks and some best practices. So before I dive into the intellectual property rights one by one, there are some things that you need to know, which are quite general and in common of all of these intellectual property rights. What you get is an exclusive right. And so they're always exclusive, which means there's only one entity who can really own them. It can be the author, it can be the one who files for the registration. And it gives you the exclusive right. So no one else can actually obtain or can use your invention or your work unless you give them permission. And with giving this permission, you usually get some money in return. And that is how you can actually monetize on your intellectual property rights. That's by granting somebody else the rights that you have obtained, or give part of those rights. And so they're always temporary as well. So it means there's no exclusive or no intellectual property rights which last forever. So there's always a temporary right. They're also territorial, which means that you cannot obtain an intellectual property right throughout the world. You have to do that for the different territorial areas. For example, the Benelux for the trademark is an area, the European Union, the United States, but you have to go there and fulfill the local requirements. But they are quite similar because there are a lot of international treaties, which makes sure that you can obtain and defend your rights throughout the world. But it needs to be done for every single territorium. So that's important. So what I will be focusing on is the Belgian situation and the European situation, because yeah, there are too many differences with the other ones. And Nina told me it would be good if we just focus on the more local, the Belgian and the European situation. So that's important to take home. So I have one slide per intellectual property right. It was quite a struggle to condense the information to this one slide. I will start with patent rights. Patent rights are the most well-known, I guess, one of the most well-known. And what they protect is an invention. An invention is a technical solution for a technical problem. And you find it most of the times. You find it's more with the engineering or the chemical sector, where you can actually file a patent on a made molecule if it can solve a certain disease, or if you can show that it has a certain function, then you can file for a patent. But not every invention is protectable. It needs to be new and non-obvious. So that's quite strict. And this novelty requirement is also very, very strict. So if you think that you've come up with an invention, do not tell anyone and do not use it in the market until you until you have investigated whether or not you will file for a patent. So I said you need to file for a patent. So registration is required. You can't really do this yourself. It's quite complicated and time intensive. So there are people who are called patent attorneys who can help you with this. But they're quite expensive people. So they're usually also freelancers, but they charge a lot of money. Why? Because they are really they're really experts in this. Then they need to really understand your invention. So they're technically quite skilled or very skilled. And they have this training which allows them to really capture the essence of your invention and describe it. So that's a bit of the special thing about patents and inventions, is that you need to go through a quite intensive procedure. So usually we do not see this in the freelance community happening quite a lot. It's more in the corporate world, where you need like a substantial budget to have a registration and of your patents, of your inventions. And there's some kind of social contract here. So you get exclusive rights. You have the exclusive rights to actually commercialize your invention. But you need to disclose exactly how you do it. And so you need to spill all the secrets, because what you get in return is this monopoly, this exclusive right for a period of 20 years. But in return, the government wants other people, the civilians, to learn about what you've done. And so you need to disclose exactly how it works, so other people can actually build on that knowledge. And so it's the opposite of the last one. We will see a trade secret. You need to spill every little detail to make other people possible, or to build actually further on your invention. So who owns the rights here? So it's whoever files the patent, it's the inventor. So be aware of contractors. If you make an invention, make sure it's clearly written in your agreement who owns the right and who can file for this invention, and if there's any extra or additional compensation you need or you want, if you can obtain a patent. With employees, it's usually the employer who owns the rights, but it depends whether or not it was the task of this employee to actually make these kind of inventions. So if it had nothing to do with the day-to-day job of your employee, then you will not, as an employer, be the owner. The other way around, if you're an employee, probably not, because we're all freelancers here. Then it's not. It's only if you're really paid to do this research and to make these inventions. So as said, a period of protection is 20 years. It's not one time 20 years. Actually, you have to renew your patent every year, and it gets more expensive the way, the further we are in time. And so the first year it's quite cheap. The last year you pay a lot of money to actually, it's some kind of tax that you pay to keep your title, to keep your invention alive. So I hope this is clear. So it's something technical. It's a technical solution, technical problem, and it needs to be new and non-obvious. So in short. So the next one, the other one is called copyrights. What is protected here? Those are actually works of literature, which is stated, and art. But actually, during the many years that the copyrights exist, so they were created by a treaty in 1836, the Berner Convention. Actually, it has gotten a much more broad application than originally anticipated. And so they actually wanted to originally protect authors, people who write works of literature, and people who make art. And so the real artists with a big A, I'm not sure whether you say that way in English, but that's what they wanted to protect, what they wanted to help. But actually what they saw is that during time, during disputes, the judges really broadened this field of application all over the world. And so now the texts, all kinds of photos, but also layout of websites are protected by copyrights. And so it's a very easy to get this. It needs to be a concrete shape. So you have to create something. An ID is not protected by copyright. You have to really materialize on your ID. So you give it a certain expression. And this expression needs to be original. And original is actually the key term here. Original means that you have had some intellectual freedom, that you've made certain choices of your own, which results in this expression of yours. And so the example I usually give is if I ask you to draw like a sunset, everybody will come up with something else. The idea or the fact that you have to draw a sunset is not protected by copyright. But your specific expression of how you see a sunset will be original, because you can, I did not give you any instructions. Will it need to be color? Will it be on the beach, in the mountains? You can do it, you can choose everything yourself. So you will come up with, everybody will come up with a different expression. And so that expression was original because it has your markings on it, and you had to make your own choices. Same things goes for text on a website. Same things goes for every photo that you take, because it's your angle, it's your subject, it's your framing, it's your lighting effects that you put onto them. So they will all be original. So it goes, the same goes for video material, for logos that you create, everything that you design, that you give a certain expression, will quite easily be stamped as, yes, this is original. It will be marked as protected as a work of literature or as art. So once you've created this, what do you need to do to get protection, to get your copyrights on that work? Absolutely nothing. So you don't need to register. So it's a really low threshold. It exists as of the moment that you express your ID. And if the originality is there, then you get your authorship and you get your copyrights. So who owns them? So it's always the author. It's never a company. It's always somebody from flesh and blood. We call it the natural persons in legalese. So it's you and me who own those copyrights. Even if you're an employee, or if you're a contractor freelancer and you do like what they call in English, a work made for hire. And so if you're hired to make this kind of work in Belgium and in Europe, there is no presumption that you transfer your copyrights to your assigner. So it's not in the US. There is more this work made for a hire principle, where they say, well, I pay the bill, I get the rights. But that's not the case in Belgium and not the case in Europe. You really need to transfer these rights, or at least make agreements with whoever makes something for you, or you make something for somebody else. Enter into this understanding of what can he or she do with your work. And so you need to put that in writing. Why? Because those authors, they're always protected. They are seen as the economic party which has the less power. And so it's always the authors are the ones who are protected by the Copyright Act. So that's important. There are two kinds of rights which are granted to an author. One are the one, on the one hand, we have the economic rights. So that are the rights to actually make or give permission that your work is being put into the market. For example, if you make a photo and you send it to publisher, they're not just allowed because you send it to them. They're not allowed to publish it on their website or to print it in their newspaper. You really need to give them what they call the economic rights, or at least give them a certain economic right. You can say, well, you can publish it on Tuesday or Wednesday, the 15th of October, and you can print it in this newspaper, or you can use it online for a period of like 1 year. Those are all things that you can agree on with whoever you do the work for. Usually for them, it will be important that they get as many rights as possible. But that is something that you need to agree on beforehand. And so those are the economic rights. The moral rights are also quite important in copyright. These entail that you can actually call yourself the author of that work. And so it's called the paternity right. You can actually claim the fact that you've created it, even though your economic rights are transferred to publisher or are transferred to somebody else. You can still claim, you can still say, well, I'm the author of this work. This is your right. And they exist for a very long period of time. It's 70 years after the death of the author. So that means that your children and your parents, they can actually benefit still from your economic rights on the works that you've created during your lifetime. And so that's a quite a long period. And it actually goes back into the days where people tended not to be able to actually exploit or to market their works during their lifetime. Look at all those famous painters who got successful after their death. So that's why actually copyright still exists after the death of the author. So that's important. So very quickly, I go through that. Software, also very important. A lot of people are working in the software sector, in the IT sector. So what is protected here and how do we protect it here in Europe? What is protected is a computer program, which means it's a source code and all the object code. So the source code is the human readable programming language that you write or that is written, that's protected. And the object code are actually after the compilation, all the ones and zeros which give the instruction to the computer. Those two things are protected, but as well all preparatory materials. And that's quite important, even if you're not really technical, but if you describe how your computer program should look like, if you have an idea for an app and you write it and you make like these screenshots or the flow chart one, if you press there, then it needs to do this, and you really design it yourself and you work out the flow, and somebody else makes the source code, you're also considered as an author of this computer program, and you also have copyrights on this computer program, because we do not protect in Europe the software as an invention. In the US, they do it as a patent right, so you have to file for protection for your computer program. In Europe, we've decided in '94 that it was important, that it was much easier to obtain protection for your computer programs. And so we actually consider them as a work of literature. And so it's protected under the copyright scheme. So that means also here there's no registration required. So as of the moment that you make this, you will get you will be granted these author rights, these copyrights on the software. So again, here, who owns the rights? If you make it as a work for hire, there is no presumption of any transfer of any granting of rights to the one who gives you this assignment. The other way around, if you ask somebody to develop your app, you will not get the copyrights if you do not put it in writing. So this is really important. Make sure that you make the correct agreement with regard to who owns these copyrights. An important difference between the software copyright and the usual or the regular copyright is that when you write a computer program as an employee, your employer is presumed to have transferred or to have gotten all these copyrights. So that's not the case for the copyrights as such. Also here, there are economic rights which are granted. So the right to make copies of your computer program. There are also moral rights granted, and the same period of protection here applies, which is extremely long in the world of software. Of course, it's 70 years after the death of the author. So I guess the first computer programs, which were still on these cards in a very mechanical computer, they're still not in the public domain. They're still protected by copyright because those people died in the late 60s, I guess, if I'm informed correctly. So they still have rights on that. Nobody still uses this, so they have no value, but still there are rights which relate to that. Another really important one is trademarks. I've put here above the trademarks, I've put the R with a circle and the TM. I will explain, this is important. This is really something that happens in the US, and there are a lot of misunderstandings about this. So I'll explain. So what do we protect here? It's actually what they call a sign. It's a word or an image, like a word like Coca-Cola, or the logo of Coca-Cola is a good example of a trademark. And this word or this sign is being used to actually make sure that you indicate the origin of the goods or the services, which means that they need to be able to show, well, okay, this service is rendered under this name. You can expect a certain quality from it. And so it has to be able to indicate where or who delivers these services or these goods. And to be able to do that, your sign needs to be able to distinct your origin. And so it needs to be distinctive, which means that actually you cannot describe your service too literally. And so that will not be a good trademark. If you sell, if your product is milk and your trademark is milk, it will not be distinct. Nobody will know, this is a company called Milk, which makes milk. Otherwise, if you have a computer and you call it Apple, that's very distinct because it's a product name, Apple, but if you use it for a computer, this is really, everybody knows what it is about. It's a name. It's also the sign, which is really, really recognizable. Everybody knows how it looks like. So that's distinctiveness. Another thing that you need, it needs to be admissible. For example, it cannot be against the public order or the good faith. So it's not allowed, for example, to file a trademark in the shape of a swastika or flags of a country. You cannot really use that to make the origin of your goods or services aware. And it still needs to be available, which means that nobody else can actually have already filed this name, so the name or the logo, for the same products and for that to distinct the origin of the same goods or the same services. You need to register. You cannot have any trademark protection without registration, and that's different in the US than in Europe. And that's why they use these two different signs, these two different, so the TM and the R with the circle around. The R with the circle around is actually a registered trademark, and the TM is a non-registered trademark. But here in Europe, we do not really have this notion of an unregistered trademark. We have trade names, which has a certain effect. You also have like your company name, but it's much less rights that you are granted than a registered trademark. And so be aware of that. The TM does not mean anything here in Europe. And it's also no obligation to put an R or a TM next to your name of your trade name. It's just to give notice to the people that you've registered, but even though they're not aware that you've registered, you still have these rights. And so you need to register. And contrary to the patent rights that we've discussed, this is quite simple to do. It's very fast that you can do that. You can obtain a registered trademark in a couple of hours, actually, or a couple of days. And you can go and do that yourself. In the most of the countries, it's because it's always it's online that you can do that. But if you're really serious about it, I would ask some advice to trademark specialist. It does not need to be very expensive, but they will actually give you some advice on is it a good trademark? Is it distinct enough? Is it something that's admissible? And of course, they will also investigate whether or not it's still available. So don't put any money in developing your beautiful logo or your name if it's already being used by somebody else in Europe or somebody else where you're active. And so that's what they will find out. You can do this yourself, but it takes some time. And so my suggestion would be that you've asked a little advice, but it does not really need to be very expensive. To give you an idea, to file like a European trademark, it's called a community trademark. It's valid in all member states of the European Union. It's a cost of 900 euros if you do it online, and you get your protection for 10 years. So that's 90 euros per year to have like an exclusive right to use this sign in the European market. And so this is very, very cheap, and I would recommend it that you investigate. If you're building a brand, if you're building a name, you should register this in your territorium. So Creative Shelter, the logo and the name is registered in the Benelux. Innovation Shelter, the same, also the logo and the name. Why not European? Because we only have like a product for Belgium, and there is no such thing as a Belgian trademark. It's the territorium is the Benelux, so that's important. So really take a look at that if you're into branding and if you have your own name. So who owns the rights? Actually, whoever files for the registration. So you can choose to do that from your company or from your personal name. You can actually choose, but go ahead and do that. But be careful with copyrights on the sign. What do I mean by that? If you have your name, for example, I came up with the name Creative Shelter. So the name, actually, I invented, but it's not really invented, just the name. I have no really rights to that. I've filed for a trademark protection. I did it from my company, the Creative Shelter BV. That's my limited company. She has filed actually for the trademark protection. But I also asked a designer to make a logo for Creative Shelter. So as explained, a logo is something that's an expression. It's a concrete expression, and it's original because I did not give any detailed instruction to this lady who created my logo. So she can actually be considered the author of this logo, and so that's copyright protected as such. So I need to be sure so that she actually transferred these copyrights to my company. But even if I would not have done that, I can still file a trademark with my company on that logo. But does that mean that she automatically also transferred her copyrights? No. So I still can stop other people or other companies using my sign or a similar sign, but still she can stop me from using her copyright protected logo, even though I've paid for it for her to develop it. And so, of course, I entered into an agreement with her, but if I would not have done that, she would still own this copyright. So that's why I say be careful with the copyrights on the sign. If you create a logo or you have it made, make sure that you enter into this agreement that you have a transfer of rights. What kind of rights are actually granted to a trademark owner? You have actually the exclusive right to use the name or the sign, so the word or the image, in the economical in practice, and so you can market this exclusively. And so in the Benelux, nobody else can actually use the name Creative Shelter or can actually have the same or a similar logo. But is it absolute? No, it has to be for certain products or services that you register for. And so that's why you ask advice, because you really need to be very considerate when you file your trademark for what kind of services will I render now and in the future. What am I looking protection for? And so that's something that they will do. And then I can stop everybody within my domain. That's consultancy. It's also with regard to legal advice that I've asked protection. So nobody else in the Benelux can actually use a similar name or the same name as Creative Shelter. So how long does this, what kind of period do I have protection? It's actually 10 years that you have protection, and you have to pay a fee for every 10 years, but you can renew this unlimited. So the most famous trademarks in the world are there for already a lot of decades. So it's something, like I said, it's always temporary, but here in trademarks, in the fact, you can actually renew it for as long as you want, but you have to pay your tax in time, of course. So that's an important and some practical intellectual property rights as a trademark. Another one that I would actually, yeah, of course, I think everybody does this for yourself, but maybe you're not aware that it's also an intellectual property right. It's a domain name. So that is actually the use of your name under a TLD. A TLD is a top level domain. It can be .be, .eu. We have a lot of generic TLDs lately. And so zoom.us exists, it's .com. So you need to register your name under a certain TLD. And so you need to do that for every top level domain. And whoever does this registration gets the right to use this, this name. And a lot of disputes arrive here with people who actually filed for a trademark and then see that the domain name was stolen or hacked. So there was a lot of those domain name hijacking happening a decade ago. And so they found something. And so if you have like a trademark, if you've registered trademark, you can actually stop or get the domain names that other people have filed without actually using it. If they have done this in bad faith, you can get it in a quite simple and in a completely online way. You can actually get back your domain name. So that's important. And then just Google this Uniform Domain Name Dispute Resolution Policy, this UDRP. And if you would be faced by somebody who actually got your domain name without you asking or without your permission. I think this is the last one. It's a trade secret. So what is protected here? Actually, it's information. It's a secret information that has a commercial value because of its secrecy. The most common example is the recipe of Coca-Cola. So Coca-Cola was able to actually make something, and still until today, nobody really knows the recipe. And probably if they would have chosen back in the days to file for a patent, probably they would have obtained it because it was something new. It was probably the way that they made it was non-obvious, because until today, nobody can really make the same taste or have the same production. But as explained, it would have taken only maximum 20 years that they would have like this exclusive rights on their way of production. So they were smart, or they considered this, and they say, well, what if we keep it a secret? Then it also has some kind of value. We do not need to disclose it, or we will never disclose it, but they don't have really any intellectual property right as such, but they have some kind of economic advantage. And it was exactly because of the fact that a lot of companies were actually hiding their secrets, or actually hiding their innovations, that they came up with this intellectual property rights. And now again, there's a movement again to get more out of the trade secret, but it usually is always like a combination. Certain parts of the production will be filed as a patent. The name that you market your product under will be trademark protected. But certain aspects, of course, are still very valuable as a secret, and so everybody has like these trade secrets. And so then you have certain protection, but it's not really an intellectual property right as such. But it's also like a very fair tactic to go about and think about is, will we disclose our knowledge and get an exclusive right for 20 years under the form of an invention, of a patent, or will we keep it as a secret? But of course, once the secret is out, everybody can use it, and there's no way of stopping it then. And so who owns these rights, these trade secrets? It's whoever owns and controls the information, which is part of the secret. So to round up, I still have like 2 minutes left, so I'm a bit over time, so sorry for that. Some tips and tricks. So make sure that you put in writing all the agreements, or all the agreements that you've made with regard to software, with copyright, and with the inventions, with patents. Make sure that you do not give away too much of your knowledge, of your intellectual property rights, to the ones who pay your invoice. But on the other way around, if somebody designs for you your logo, make sure that you get these copyrights. In a lot of countries, there are tax incentives. In Belgium, there are very favorable tax incentives for copyrights and also for software, because it's also a form of copyright. If you want to learn more about them, come and talk to us. There's no time to really go into depth into that. But check also your country, whether or not there are any tax incentives for these intellectual property rights. I know in the Netherlands, there are, in Luxembourg, in France, in Germany, there are a lot of tax incentives with regard to intellectual property rights. I would file for a trademark, investigate whether or not your sign is still available, if it's distinct, and seek some help within your local area with a trademark attorney. They will normally, for a fair price, you have your trademark, you have some kind of intellectual property right. File your domain names, make sure that you do it before, as soon as possible. Probably you've all done that. And keep your eyes open for elements which are made by third parties. If you have a website and you ask a photographer to make some photos that you want to put online, make sure you get permission to put them online. Somebody makes the design of your website, of your logos, or write some software, make sure that you enter into these agreements. And also keep your eyes open, if you're in the software industry, for open source software. I have no time to go into detail, but if there are any questions with regard to that, you can also, of course, contact us. So those are my few tips and tricks. I think the takeaway message is have a look at the bigger picture. There are different intellectual property rights maybe that you can obtain, or you maybe already have obtained, and make sure that you put in writing these agreements that you've made with your assigners or the people that you give assignments to.